everybody. This is American Nana. Let me see this glare. I just can't. So it is in the evening, and well, it's my time. It's 11 o'clock. I'm not sure, but I think possibly I have this one where it's actually live. This is all tests, guys. So bear with me. So I did half of the pre-motion, and now I'm going to pick back up, and it's going to be Lowly. So we'll just pick up where we left off and see what we see. I'm really interested in this because of how Beverly acted during the trial. I'm curious to see if it was all before the trial as well. So let's give it a try. All right, here we go. Lowly. Oh my gosh. Well, hey, Boston Grandma, how are you? I'm just going through some motions I'm interested in and thought I would share them. It's good to see you. I've never done this by myself. I don't think I've ever done this. So, welcome. All right, here we go.
Are concerned to Mr. O'Keefe's right arm and right forearm. They've always and consistently been described as abrasions caused by blunt force trauma, not road rash. I'm not really sure where the road rash comes from. What I would submit in conjunction with that is, again, divorcing whatever evidence the defendant claims from the context of the rest of the evidence and the rest of the case. It's a little peculiar and conspicuously clear from the defendant's fact section that the damages to the right rear corner panel of the defendant's vehicle, embedded within the bumper to that vehicle, is pieces of a cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video, external surveillance video from the Waterfall establishment that he left just prior to going to 34 Fairview, with a cocktail glass in his right hand. Same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car. As the court is well aware, and I just stated for the records, under Rule 17,
As if the glass could
burden,
do that, right?
Or the moving party has the burden to establish that the documents are evidentiary and relevant. Secondly, that they are not otherwise procurable reasonably in advance of trial. Thirdly, that the party cannot properly prepare for trial without such production and inspection. And fourthly, that the application is made in good faith and is not intended as a general fishing expedition. The issue that the Commonwealth takes with the defendant's request as it applies to these particular records is with number 1 and number 4. The Commonwealth would submit that the showing from the defendant is simply insufficient to establish any relevancy or evidentiary value to these records. And then secondly, that this is the very epitome of a fishing expedition. The indication, even from the verbiage that's used by counsel in the motion, sheds light as far as as I just stated, the sort of epitome of a fishing expedition. It's language such as it could shed light, or if true, this fact would undermine the prosecution's entire theory of the case. There have been a couple of theories that are stated within the context of counsel's motion. I can state for the record, those are not the Commonwealth's theories. No one ever said that the vehicle struck Mr. O'Keefe in the head and that's what caused the injuries. That's actually not at all what the grand jury testimony or the evidence has shown throughout the course of this.
Okay, the problem with this is I don't think he's ever bothered to say how the arm was injured, except what? The glass? The glass did it. The glass that he carried, which I don't under yeah, we do, don't we? They made such a humongous deal out of Karen Reed having a glass and bringing it from McCarthy's to the waterfall, which I don't think that was true because it was just, Jennifer McCabe and either her friend or her sister that said that, right? So then Lally's up here, and I mean, this is nothing but just salad. How did it go to court? I don't get it.
Investigation throughout the course of this case. But those could, and if true, those very words by definition evince the very nature of this particular request. The first issue would be with the time frame, as it's stated within the motion. It's from 2015 to present. I'm not sure why so expansive a time frame is needed or necessary or relevant to anything that is a subject matter before the court. As counsel suggests, that photographs of Mr. O'Keefe's injuries suggest that he was severely beaten and left for dead, having sustained blunt force injuries to both sides of his face as well as to the back of his head, that there's evidence of defensive wounds, there's a cluster of deep scratches and puncture wounds to his upper arm and forearm, and then the defendant essentially asked the court to take the then inferential leap that these injuries, which are wholly inconsistent with the injuries noted by both the emergency medical personnel at Good Samaritan, where Mr. O'Keefe was taken immediately from the scene where his body was discovered, and from the medical examiner's finding and sworn testimony. So wholly inconsistent with those, that these are, then take the inferential leap that these are consistent with bite marks or scratch marks from an animal, specifically a dog. In support of these assertions, as counsel stated, there's
Specifically a dog. How about because it was a dog? I mean, what else was it? Oh, the glass did it. Such a dummy.
an affidavit from Dr. Frank Sheridan that the injuries are consistent with animal claw or scratch marks.
That's not me, that's them.
Well, we've had an interrupt in the feed there from the courthouse at the Dedham Court, but we've been listening to attorneys talk about their motions in the case of Karen Reed. Let's go back.
As far as how the medical professionals detail what those injuries are. In those medical records, what the personnel at Good Samaritan, the doctors and nurses who examined Mr. O'Keefe when he came into their facility, they described his injuries as a right superior orbital ridge region, approximately 7 millimeter laceration. Positive for surrounding soft tissue, swelling, and positive breath sounds bilaterally, pulseless.
That wasn't me
positive
either.
superficial abrasions to the right forearm. Dr. Scortibello, the medical examiner in this case, who testified at length before the grand jury, described Mr. O'Keefe's right arm injuries as scratches caused by a blunt object. She described or noted that they appeared to be in a linear pattern.
Or bite.
She detailed that she observed no signs of an altercation or fight from her thorough internal and external examination of Mr. O'Keefe. And lastly, she testified in great detail as to the swelling of his eyes being related to the fractures in his skull how those manifested into the observable swelling and discoloration of his face. And essentially what she testified to was that there was a laceration on the right back of Mr. O'Keefe's head, that there was a skull fracture in that immediate area, the right parietal area of the victim's skull. That then caused a swelling on the brain, which she observed as well as Dr. Stonebridge observed during her neuropathology examination of Mr. O'Keefe's brain post-mortem. That then caused the swelling underneath of the skull, caused the radiating skull fractures that she observed in Mr. O'Keefe's skull throughout, and that the essentially nowhere else for the blood to go, and the looseness of the vascular tissue behind the eye then causes both of the eyes to swell. There was no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds. She was specifically asked those questions and testified to that before the grand jury as to those injuries and how they sustained. There's absolutely no evidence that Mr. O'Keefe ever entered the residence at Fairview on that particular evening. Counsel mischaracterizes some other statements made by a witness, Mr. Brian Nagel, who had come to pick up his sister at the residence. She came out, he observed that vehicle. He observes that vehicle from the entirety of the time that he's there. So he's pulling on to Fairview. Ms. Reed is coming on to Fairview in the opposite direction. The right blinker on and a left blinker on. The operator of the vehicle that Mr. Nagel is in then essentially flashes his lights and allows
My
Ms.
gosh,
Reed to
it
pull in
puts
first.
everybody to sleep.
Mr. Nagel is there the entire time that Ms. Reed pulls onto the street when she pulls up. Indicates that she initially pulls over to the right-hand side of the curb, then pulls the vehicle forward a little bit further. That's corroborated in testimony from a number of different people who were inside the house, as well as Mr. Nagel's sister, who then came out of the house and talked to her brother at the door of the truck that he was riding. Mr. Nagel further indicated that at no point did the brake lights come off, including the center top light of the SUV that he observed in front of the house. There were no footprints outside of the vehicle. He never saw anyone exit the vehicle. No one in the house reported ever
They only saw one
having
person,
anyone
Karen
come
Reed.
inside the house or seeing anyone exit the vehicle. And I'm a little confused just as far as counsel's statements, as far as the multiple people saw Mr. O'Keefe or never saw Mr. O'Keefe come into the house. Or if he comes into the house and he's attacked by the dog, I'm just a little confused as far as are they in the conspiracy, or are these people sort of let
I'm
out
a
of the
little
conspiracy
confused. He's such a
into
smart ass.
something that doesn't further that conspiracy? If they're all dragged out to the bottom of the lawn and left there for dead, then why do they all testify that no one came into the house? It's consistent throughout
Why did
the
they
entirety of all
testify?
the witnesses. It's consistent with Mr. Nagel as well.
Okay, I don't think I ever caught this before. Why do they all testify the way they did? Uh, because human beings also had something to do with his death, not just the dog. Nobody said that the dog killed Officer John O'Keefe. Yeah, I mean, could he just can't get any stupider.
It's consistent with the forensic evidence. It's consistent with every piece of evidence that has come to light at this point.
I'm sorry. So this is May of 2023, and they're still saying everything has all the evidence points to Karen Reed, but they haven't gotten any of the evidence. I was going to say prosecuted. What is the word? You know, where you check things out. They haven't checked it out. Oh God, he will. I mean, the other day he almost put me to sleep. But yeah, but he makes no sense if you listen to what he says. But he's always such a smart ass. You know, he tries to get back to Jackson and Yannetti. They're very smooth in their delivery of Lally being a dumbass, and he thinks that his little smart but attitude. I'm confused. Well, we all know he's going to be a smart aleck, right? It just makes me so mad. No, he has nothing, Cheryl. Nothing.
And there's further
Hearsay.
statements in regard to the dog. Some reported incidents several months after the death of Mr. O'Keefe. The counsel suggests ineluctably that the animal was violent and prone to violence from one incident that postdates this particular time frame of Mr. O'Keefe's death, and seems to punctuate
Look at this guy over here.
this
He
circumspection
looks like he's falling asleep.
on and on about how violent the dog is from an incident that he has no information about, whether or not it involved another animal, whether or not it involved another human, whether or not it involved what exactly the incident occurred. This is simply not what Rule 17 is to be used for. That's what the case law has consistently held, is that it is not a discovery tool. It is based on information, relevant evidentiary support, which is completely and utterly lacking in this particular motion, in this particular submission. So for those reasons, the Commonwealth would request that the motion be denied.
Okay.
And it's certainly lacking on his side too. My
So
gosh.
the second Rule 17 motion, are we going forward on that and then having the hearing regarding the timing of the video? How are we going forward with this before I hear from you on the substance, Mr. Jackson? What is the next date for?
May 25th.
Right, what's it for? The evidentiary hearing?
Yes.
All right.
What's
So
it
do you plan on
for?
arguing your Rule 17 motion today or that day? Not both?
That day.
Okay.
I'd rather reserve and
That
argue
makes sense to
17th that day.
That makes sense to me as well. So we're finished for today, unless there was any follow-up to Mr. Lally. And I'm
There
not
is.
going to hear a preview on the motion that we're going to hear on that. Day.
That's fine.
Yeah.
Thank you. With regard to
I
the
see stuff.
dog,
I'm like, oh no, I didn't do it.
fight inside the house with the dog's owner, the dog would likely attack. That is the idea that is borne out by the evidence that we have. We know that
Those
he was
guards
beaten.
crack me up
We've
too.
got
Look at
evidence
them.
that John O'Keefe was beaten, that he lay there unconscious. And we also have evidence that at the time he was beaten facially and blunt force was used against the back of his head, he was also attacked by an animal. Well, Brian Albert, who's a known fighter, owns a 90-pound German Shepherd that has since been gotten rid of and had a skin-piercing incident as the excuse for having gotten rid of it. So we know that the dog attacks, according to sort of uncontroverted evidence. We weren't saying, we don't suggest that the dog killed John O'Keefe. We're suggesting that the dog was there when John O'Keefe died and also attacked John
Wow.
O'Keefe.
And even
That's
us
the point.
little lowlifes can
Um,
figure that out.
This is the first I've heard
Lally
of the
can't.
Commonwealth's new position after, 15, 16 months, that somehow John O'Keefe with a broken cocktail glass, which would produce these injuries. That makes absolutely no sense. It just doesn't pass the sniff test. These are
The
not
sniff
from
test. I
a
love that.
cocktail
The
glass.
sniff test.
Who did that to him? Is there a new theory that Karen Reed got out of the car, broke a cocktail glass, then wielded an edge of that cocktail glass and cut up John's arm? Then John stood there
Or
while
she
she
did
jumps
it.
in the car, slams it into reverse, then hits him with the car
Boys watching.
with her tail light in the back of the head. It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck,
It's a
it's a
dog.
duck. This looks like an animal attack because it is an animal attack.
Clearly.
At the same time, temporally, at the same time that he was otherwise beaten and then ultimately left for dead.
I feel so stupid doing this.
Interestingly,
I really
that
feel
it-
stupid
it's
with
interesting
the
that the
headphones
Commonwealth
on.
doesn't mention the basement because that's very likely exactly where John O'Keefe went once he walked into the house. There's no evidence that John O'Keefe walked into the house. The Commonwealth has evidence that John O'Keefe went to the house. They haven't. They just sat on it for several years or for several months, over a year. That the Apple Health data
Oh, this right
from
here.
John O'Keefe's own phone
Mm-mm-mm.
establishes that once he was at the location at 34 Fairview, he climbed 3 sets of stairs. The Albert house happens to be 3 floors, a basement, a middle floor, and an upstairs. His Apple Health data also shows that he took multiple steps after he left the car, after he left Karen Reed's vehicle. The multiple steps indicate that he was in the house. If, in fact, the Commonwealth were correct, and he stepped out of the car, was hit by the car, and fell down and died, if that's what their theory is, you would have no Apple Health data suggesting that he was climbing stairs and walking about as if he were inside the house and was ushered down to the basement, at which point there was a fight, he was beaten to unconsciousness, and then everybody in the house leaves, not having to go down to the basement. There's a door that services that basement that's closed. So there's no reason for people who are upstairs, either upstairs or on the main floor of the house, to even know that there had been a fight downstairs, or that John O'Keefe never made it out of the house alive or conscious.
I was talking about
With regard to
duckies.
Brian Nagel, The Commonwealth leaves out probably the most important part of his testimony. Ryan Nagel's testimony is that he arrived just after Karen Reed arrived. They arrived not at the exact same time. She turned down the road. Then he turned down the road. As he approached the road, as he approached the house, he then pulls to a stop. He had her car in his sights the entire time, just after she had already arrived. Certainly time enough for John to get out of the car and walk toward the front door. He said that he observed that there was no taillight damage whatsoever. He later observed inside, either through a dome light or through other ambient light, that he could see inside the passenger compartment of her car, and that she sat there alone. And most important, he didn't see her hit anybody with her SUV. That's the most important part of Ryan Nagel's testimony. He didn't see her hit John with the car.
And
which
he didn't
would have
see
had to have
John
seen
in the car.
if he was situated right behind her. And the Commonwealth has repeated what they've oft repeated several times, which is there was no sign at all of any kind of an altercation or fight. Well, if there's no sign of an altercation or fight, how can you turn around and say that a cocktail glass did this?
Exactly.
They can't talk out of both sides of their mouth. How could they reasonably ignore two black eyes, a laceration over his right eye, a laceration at his nose? He looked like he had gone 10 rounds with Mike Tyson, as my colleague has once analogized. Of course there's evidence that he was in a fight. The back of his hands, deeply bruised. Those are called defensive wounds. I don't care what their medical examiner called it. Anybody who's seen any sort of a fight, a street fight, knows that the back of the hands, the back of the arms get the brunt of the punches as you cover your face. Of course there were signs of a fight. Not just a fight, a brutal fight.
Man, he always gets your attention.
And what does a dog do when its
Keeps
owner is in a fight? What does a German Shepherd do when its owner is in a fight?
Attacks.
Reaches out and attacks and supports his owner. And what does a person do when a dog attacks? Usually puts his arm up, his dominant arm up, to protect himself. And that's where the lacerations, the bite marks, the claw marks appear on John O'Keefe's arm. This is not a fishing expedition. The Commonwealth has an unreasonable expectation. They cite to words that we use what the evidence might show, what it could show, what it potentially will show, as a weapon to say, well, see, they don't know what the records are going to show. Well, if I knew what the records are going to show, I already have the records. I wouldn't need the court to ask for them. Of course, I don't know everything that's in the records. And the reason that we asked, Your Honor, for 2015 is because we have evidence that in 2017, the dog looked full grown. So we wanted to go back and bracket the proper amount of time. Say the dog was a couple of years old at the time that photograph was taken in 2017, we want all the records associated with that dog, which means we bracketed our request. It's not overly burdensome. It's certainly not burdensome
Kind of sick, twisted
to the
person
Kent
gets
Animal
rid of
Control, and
their
it's not
family
burdensome.
dog. Yeah, well, they didn't even refer to her as Chloe.
To the Kent, they're too old. But that's why we bracketed our request to go back from 2015 to present. And with that, Your Honor, I believe that we have made a good faith showing. We have met the standards of Lampron, all four standards of Lampron, and the summonses should issue. And also,
All right. Anything else, Mr. Lally?
Just briefly, Your Honor, as it pertains to
Oh, here comes the smart ass.
Commonwealth would agree that attributing the cuts on Mr. O'Keefe's arm in their entirety to cocktail glass would be somewhat ridiculous. That's not what I said.
What would you say?
And that's not what I was attributing them to. And I think the court understood that, but just so counsel understands that as well.
I don't think
pertains
anybody
to, Mr.
understands
Nagel,
Lally.
What is in his testimony is that he had the vehicle, they arrived at the residence in tandem. The vehicle was there when Mr. Nagel left. So while he sees no one exit the vehicle, no one enter the house, and no one else sees anyone exit the vehicle or enter the house during that specific time frame, the defendant, in and presumably Mr. O'Keefe, are still there and still in the vehicle at the time Mr. Nagel leaves the house.
Except
That
they
was the
didn't
point that I was
see
making
him
with that.
in the
As it
car.
pertains to the Apple Health data, and obviously we'll get into
Oh,
this a
this
little
right
bit more when
here.
it comes to that subsequent Rule 17 motion, the Apple Health
What a
data is
liar.
the same Apple Health data that's being relied upon for the supposition that Mr. O'Keefe went inside the house. That same Apple Health data has, among other things, Mr. O'Keefe taking 46 steps and traveling a certain bit of distance around 11:56 a.m. on January 29th.
That's
The
so
problem with that
misleading
is
right
that he
here.
was pronounced deceased at the Good Samaritan Medical Center at 7:50 a.m., some 4 hours prior to that. In addition to that, from the
Okay, I'm sorry. I have to stop it here. You know, what judge buys what just came out of his mouth? That who buys that? The Apple Health data was still, you know, it was still running. John O'Keefe is on his way to the morgue, but the Apple Health data is still counting steps. Lally knows good and well it's because the phone had not been secured. Yeah, Auntie Bev allows everything. I'm just, I have no idea if I'm boring you to death, Cheryl, but I appreciate you being here. I just can't keep my mouth shut.
information as far as when that ascending or descending of stairs occurred between, I believe it's 12:21 and 12:24 a.m. There's a Waze search and location data for Mr.
And
O'Keefe's
this
phone.
is
The
all
Waze
so
search is conducted,
stupid.
and the GPS location information from Mr. O'Keefe's phone shows him en route to the house and not arriving at the house until 12:24 a.m. So the information the council is relying on has him going up and down 3 flights of stairs before he's even at the house. So for those reasons, again, the
According
Commonwealth would,
to Lally.
submit the defendant has not met its burden and ask that the motion be denied. Before we do conclude, I just did want to remind the court there are a couple of the other issues that I need to address with the court, specifically the Commonwealth's motions to impound and the Commonwealth's motion for access to the defendant's phone.
Such a slick guy. He's
I'll hear
sickening.
you.
So there were
You notice he just
two
stood there. He
motions
knew he was
to
going to get his
impound the
way and
Commonwealth
get the
filed.
call.
One pertains to the grand jury transcripts and exhibits that I had attached as attachments or exhibits to the opposition to this specific motion. To really,
Yeah. She sure does help him.
And those are impounded by statute.
right. The other Rule 7 records of Ms. McCabe and Mr. Albert. Now, certainly, the Commonwealth is not saying in any way, shape, or form that those items shouldn't be submitted. The defendant can submit whatever she wants, whatever counsel wants in support of that request for the court to review. But the manner in which the information is released, and specifically what I take issue with, and I'd be remiss if I didn't say this on behalf of the O'Keefe family.
I'm not sure I'm not sure they hear you.
Okay. In reference to the motion to impound the attachments to the defendant's Rule 17 motion for Mr. Albert's phone.
You like
with
how
all
he just
detailed
stands
records of
there?
Mr. Albert and Ms. McCabe.
Kind of disrespectful, I
I'd
would
be
think.
remiss if I didn't, on behalf of the O'Keefe family, as well as just what the statutory rules are, and specifically I'm talking about the Supreme Judicial Court, Rule 124, pertaining to protection of personal identifying information and publicly accessible court documents, which I would imagine that at least Mr. Unetti, even if Mr. Jackson and Ms. Little aren't familiar with, does provide rules as to how things are filed that are
Such a
that kind of
smart-ass.
sensitive nature and that kind of biographical
Excuse
information.
me, but he
And
is.
they're routinely filed with the court with a motion to impound or a motion to seal, and not filed directly with the media. The issue being that there are photographs depicting Mr. O'Keefe's postmortem at the Good Samaritan Medical Center, as well as possibly some autopsy photos that should have been impounded. There are unredacted Canton Police Department reports, multiple copies. Again, not anything that Commonwealth takes any issue with the court reviewing, but as far as them being made public with those witnesses' names, dates of birth, social security information, addresses, phone numbers,
It's called
things of the like
redacted.
that should be impounded pursuant to the statute as well.
It
And in
bothers me.
particular, I do take issue with
You take issue
particular
with
that
everything.
motion, specifically on page 11. There is a specific reference made to the name of the decedent's niece, which is strictly prohibited as far as being
Everybody there knows
provided in a
him,
public
but I'm
document.
sure
So
they
for
would
those
have
reasons, I would
redacted
ask
it.
that the
So
attachments to that motion,
he's just
to
whining.
whatever extent it can be at this point, given the public release of them, be impounded.
Mr. Yannetti?
Your Honor, I believe that some of that information may be in the public domain already, so it may be that the cat is out of the bag with regard to some of it.
It is now, right?
I'm sorry?
It is, the cat's out of the bag now.
Right, yes. So, I mean, we're agnostic on this motion to impound. We have access to it, the Commonwealth has access to it, and most importantly, the court has access to it.
Was raised by the Commonwealth. It was supposed to have been requested to be impounded at the time it was filed. So that was not done.
Are you talking about the motion that we filed with regard to the Albert phone motion?
Yes, the attachments. Mr. Lally just outlined it.
I don't think that there were any grand jury minutes attached to that motion.
No, that was a separate motion that Mr. Lally just
Right.
filed on behalf of his
Oh,
motion.
he
we don't
just
have-
When he was
filed.
taking issue with the defendant who filed.
Right. Okay. Yeah, again, we don't have an objection at this point.
All right, Mr. Clerk, those are both allowed. All
You
right,
notice
hearing-
that-
Those are both allowed by statute. So is this hearing over?
Your Honor, if I could just
Oh
address,
my
the Commonwealth
gosh.
had filed some time ago a proposed procedure
Are we done?
regarding
Are we done?
communications
Are we
stored in
done?
the defendant's iPhone. So we had addressed this briefly, I think, on the last court hearing date in February in relation to the defendant's phone. So the defendant's phone was seized lawfully from her pursuant to a search warrant. The information contained therein was then downloaded. Communication between Ms. Reed and Mr. Yannetti, the information in that phone.
I don't know why
So
that thing
obviously
does
all,
that.
Examination of Ms. Reed's phone from the Commonwealth's perspective ceased at that time. And we had begun exploring and filing this motion. I had it in hand to file with the court on the last date. However, after several discussions with Mr. Yannetti and counsel for the defendant, I was then informed in court on the last date that the AFE or the independent sort of forensic examiner that would look at that phone was believed to have some sort of conflict. It was not acceptable to Mr. Yannetti. So there was a separate person who essentially runs the lab at the Attorney General's office, who I spoke to Mr. Yannetti about whether or not that person would be acceptable. He does have a conflict, just so the court is aware, as far as grew up in the same town as the victim and his siblings. But Mr. Yannetti indicated that he, at least verbally to me on that date, that he didn't see any issue with that conflict, as the person would just be assigning it to a couple different forensic examiners within his office. I then modified the motion to incorporate that subsequent AFE, sent a copy of the motion to counsel 6 weeks ago or so, and still have received no response. So what I'm looking for today is action on that. The other thing that I would note for the court is that counsel had asked for a raw extraction copy of the material from the defendant's phone, which was then provided to counsel on March 22nd. So for over a month, the defendant has had access to the defendant's phone, and the Commonwealth has not, because counsel has failed to respond
But
to
you've
whether or
had the
not the
phone
AFE was reliable or not. And what I was referencing on the last court date is the court had
They
indicated
took her
that if we
phone
were
the
to come
day
to
that
some
he
sort of
was
agreement,
killed.
the
She
court
never
could
got
act on the
that
papers
back.
and obviate the need to address it on this date. It hasn't happened. I would submit that the proposed protocol was more than reasonable, and I would ask that it be allowed by the court.
So, Mr. Yannetti?
Yes. I was the one to suggest that it be analyzed by the Attorney General's Office, Cyber Crimes Division. I thought that was clearly, we have no objection to that, but I'll announce it in open court. We have no objection to that. The motion for the
Ollie
protocol,
blues everybody else.
you know,
Oh my gosh.
procedure is agreed to.
And you're okay with the individual that was cited in it?
Yes, the individual who was cited in it is the head of that unit. I know who he is. I respect him. He revealed to me at the start that he has a personal conflict. I have no issue with him assigning it to somebody in his office.
So
I
the
can't tell
motion's
where the
allowed
camera
by
goes.
agreement?
That's fine.
Okay.
Thank you.
Clerk? Motion's allowed by agreement.
Just one other thing. Mr. Lally had mentioned to me, and I don't know if he still intends to be heard on this, but there was an issue of exhaustive testing that I thought.
He argued that a while ago.
Okay, and was that acted upon by the court?
He said he was waiting to hear back from you where we stood on that.
Right.
Oh
so
my gosh.
With regard to that, Judge, we're all for exhaustive testing as long as we can have our expert present at the time.
So, Mr. Lally, would you say again what you explained to me?
Certainly, Your Honor. So there's a form that's provided by the lab that I then provide to counsel. In this case, in any case, that where exhaustive testing is necessary and the sample would be subsumed within the analysis. So I provided that to counsel. I just simply need counsel to execute that form, indicate whether or not they want someone present and who that person is, what their contact information is, and then provide it to the lab. The lab will then contact their expert and schedule a time for the testing to be done.
Okay, we're happy to do that, but my understanding from Mr. Lowry's earlier argument is that only applies to the hair that was found on the car that was not part of any motion that we had today in terms of a motion to compel. What about the other evidence with regard to the tissue samples and everything else that we actually asked for in our motions today?
Is there exhaustive testing on any of those items, Mr.
Not that
Lally?
I'm aware of.
Okay, fine. Yeah, so we'll sign regarding the here. We're not concerned about it.
This should have been
Is that
handled
everything?
so long ago.
Yes.
I believe so, Judge. Thank you.
All right, thank you. We'll see you on the 25th.
Okay, so that was it. All right. So I appreciate that you came and sat with me while I did this. I'm not sure if I'm going to do the next pretrial motion. I think I am. I think I'm going to try and just keep it in line as much as I can because I missed all of anything that happened prior to the case. I did not listen to anything about the case. And as much as Lowley is just absolutely horrific to listen to, I think that I have picked up on a lot of his snarky and snippy and lying by going back through. And this is just, I mean, this should not be happening in 2023. They should have had everything tested. I mean, he went to court on her bond hearing claiming that all the evidence pointed to her, and he had nothing except Jennifer McCabe's mouth. So, no, from what I've seen, it should not have happened. And, I'm not sure if people are interested in going back to the beginning like I am. I'm just going back to the beginning because I absolutely have missed so much. And I did it on purpose. I wanted to, not have an opinion already prior to going to court. Because, like, for example, oh, what is her name? The woman that killed her husband with fentanyl. See, I've heard so much about her already that I couldn't sit on that trial because, in my opinion, she's guilty. You'd have to show me where she's not, because everything points to her, and she's done so much crap, walk the dog letter and stuff. So I'm really interested in that one. But this has just normally I'll watch a trial and then go for another and go for another, and I'm just like, oh no, full stop. I need to know everything. So I thank you for stopping in, Cheryl. I don't know who else stopped in. It shows I had a couple people here. And I hope that I wasn't too boring. I hope that doing it, I try to decide whether I'm going to do live or I've done somewhere I've streamed it, but I've not done public. And then I list it. And then this is the first one I've ever done live. I've done 2 more that are under live, but those are the ones that I did, unlisted. So, I'm just trying, and I appreciate you for coming by. I'll probably come on later on and do something else and, um, trying to figure out when to do it so that I'm not bothering the other people in the house. Oh, you're so sweet. Yeah, it is very late, and, I'm surprised that anybody even stopped by to be honest. I thought, "Well, I'll just come on here and do all this, and nobody will even know I was here. So I appreciate that. Um, I'm just a yappy person, I think. So I'm going to say goodnight on this one, and I'll do another one. Aw, well, thank you. Yeah, I'm trying. I usually am up until about 3 a.m. So I have a lot of time in the late night, and then I only have, like I did one today, and my granddaughter, she ended up on this side of me for at the very end of the video, and I wasn't gonna try to figure out how to cut it out, so I just left her in there. But I try not to do it when, when they're in the living room and stuff. So, or if my husband, I don't know if you can hear the TV because the TV's on because I'm in the living room. Oh, how fun! How many grandbabies? So my grandkids went back to school the last week, the second week of school for us. So, oh my goodness, bless you, have all 8 of them? Whew. Oh, the ages are spread apart so much in mine. The 2 little ones keep me hopping, but the older ones are much older. Wow. I bet they've enjoyed the protest. I think that's really good. Yeah, I can't remember ever protesting. Oh, for tomorrow. Aw. Oh, the oldest is 9 out of 8. Oh my goodness. My oldest is 25. My son has 3, a 25, 23, and his son's almost 17. And then my daughter has 3. The 9-year-old, she's going to be 10 next month. And then I have a grandson that is 7, and the baby bringing up the tail is 3. So, isn't it fun with busy houses though when it's your grandbabies? I laugh. My house is a mess, but I laugh because my daughter and the children live here. So it's a lot of fun. Well, you get you some sleep, and hopefully I'll get to where maybe I can figure out how to do these when, you know, people are awake. At least right now I can do it, and I can kind of hide, right? I can try to ease in. I do too. Being a Nana is one of my very favorite things in the world. I absolutely love it. I'm going to say goodnight, Cheryl, and I'm going to say goodnight to whoever else was here. According to the count, there was a couple of you. So you sleep well. Bye bye.